G'day, Shane Dowling here from kangaroocourtofaustralia.com. Now, the New South Wales Police have instituted proceedings against Jordan Shanks, who's a publisher of the YouTube channel Friendlyjordies. That's on top of proceedings they've already got afoot for stalking against Christo Lanka, who's a producer on the Friendlyjordies YouTube channel. Now, it's probably breaking news. I don't know if anyone else has reported it yet. I've come across it because I was checking the daily court list, and I decided to check Jordan Shanks as well because 4 or 5 weeks ago the police were trying to get suppression orders against him and trying to get him charged with contempt of court. So I did a search and lo and behold his name's come up. There's a separate court case against Jordan Shanks. Both the Jordan Shanks matter and the Christo Lanka matter both set down before the same magistrate on Wednesday. So we'll probably get more information then. It's my understanding the proceedings against Jordan Shanks are in relation to a suppression order. And so in this matter, or in this video, we're going to have a good look at that. Well, I'll read you out some of the background and a couple of the articles I've previously written, which gives you an overview of what's happening. And I'll also cover a couple of precedents. One's in relation to Bernard Colleray, who just recently had suppression orders lifted on his matter, and also the Capilano v Dowling matter. Now, the Capilano v Dowling matter relates to suppression orders and non-publication orders that were instituted against me, and they were lifted, and Capilano appealed and went to the full court, or the Court of Appeal, and I won 3-0, a unanimous decision in my favour. Now, the reason we'll look at both precedents, the Bernard Colleray matter was handed down in the Supreme Court of the ACT. So the magistrate here in New South Wales might, or I'm not here in New South Wales, I'm no longer in New South Wales, but the magistrate in New South Wales might say, oh, well, she's not bound by a judgment in the ACT. But the Capilano v Dowling matter was in the Supreme Court of New South Wales, and the magistrate is bound by that judgment. But firstly, I'll just read you out a couple of articles I've published on this matter, which gives you the good backgrounding of all the details. Now, on the 14th of September, I published an article titled "Corrupt New South Wales Police are Still Trying to Stitch Up Friendlyjordies for Contempt, which would breach the 2004 High Court precedent Coleman v Power." And it starts off, the New South Wales Police asked a magistrate in the New South Wales local court on the 8th of September to charge Jordan Shanks, who publishes the Friendlyjordies YouTube channel, with contempt as part of the police's criminal charges against Christo Lanka for stalking New South Wales Deputy Premier John Barilaro. The contempt application relates to Friendlyjordies publishing the below video calling various New South Wales police corrupt and publishing an affidavit by John Barilaro in the video which proves Barilaro has lied in public statements about the matter. The big problem for any contempt charge against Jordan Shanks is the 2004 High Court of Australia precedent Coleman v Power, where the High Court found that calling police corrupt and slimy lying bastards is illegal political communication. And as far as publishing Barilaro's affidavit is concerned, it clearly says on the front page, John Barilaro v Jordan Shanks, and there is no matter before the courts with that title, so to try and charge Shanks for publishing the affidavit would be scandalous. Now, further down in the article, I say Christo Lanka was charged by the Fixated Persons Investigations Unit, and I published an article on the 29th of the 8th, 21, titled "New South Wales Police Anti-Terrorism Unit Used by Politicians, Judges and Other to Intimidate and Falsely Charge Journalists Who Expose Them." And I said New South Wales Deputy Premier John Barilaro's own police statement, which has been leaked to the media, has exposed Barilaro for lying to the media about secretly using a New South Wales Police Anti-Terrorism Unit to harass and intimidate journalists, Jordan Shanks and Christo Lanka, who publish a YouTube channel, Friendlyjordies. The evidence of the New South Wales Deputy Premier John Barilaro's lies and part of his police statement are in the videos below. Now, if you have a look at another article I published, it's titled "Christian Porter Loses Another Court Case as ACT Supreme Court Refused to Suppress Key Evidence in the Political Prosecution of Bernard Colleray." It's dated the 7th of October. Now, in that article, I quote some of the judgment summary that was issued by the court, and a key paragraph is where it starts off. The Court of Appeal accepted that public disclosure of information relating to the truth of the identified matters would involve a risk of prejudice to national security. However, the court doubted that a significant risk of prejudice to national security would materialise. On the other hand, there was a very real risk of damage to the public confidence in the administration of justice if the evidence could not be publicly disclosed. The court emphasised that the open hearing of criminal trials was important because it deterred political prosecutions, allowed the public to scrutinise the actions of prosecutors, and permitted the public to properly assess the conduct of the accused person. Now, in this matter, Christo Lanka being charged by the police, and also proceedings against Jordan Shanks by the police, which relate to John Barilaro, who was the Deputy Premier at the time, Deputy New South Wales Premier. It doesn't get much more political than that. And just like the Bernard Collaery matter, there's a perception that this is a political prosecution. So to put suppression orders on anything, or even just to put suppression orders on Jordan Shanks, would undermine the public's confidence that a fair hearing has taken place. Now let's have a look at the Kapilani v Dowling matter. Now in that matter there was a super injunction, suppression orders and wide-ranging non-publication orders against me. Now I had those orders reviewed. The super injunction was lifted before the suppression orders, non-publication orders were reviewed because it was embarrassing for the court, so they lifted the super injunction. That meant I couldn't even tell anyone there was a court case. Now Kapilani v Dowling matter was a defamation matter. So the fact that they put a super injunction on it where I couldn't even tell anyone there was a court case afoot was extremely embarrassing for the court. But anyhow, that got lifted, the super injunction. But the suppression orders, non-publication orders, having them lifted, went to a hearing. And I won. Justice Lucy McKellum. Now paragraph 54 of her judgment, it says, as already noted, the principal basis for the application for interlocutory injunctions in these proceedings is to preserve the efficacy of the relief sought against Mr Mulvaney. However, there is no suppression or non-publication order in those proceedings. Any person other than Mr Dowling is free to report on those proceedings. It is an ordinary feature of proceedings for defamation and injurious falsehood that the conduct of the proceedings will result in the ventilation of the very defamation or falsehood in respect of which a remedy is sought. Now in the defamation matter, Kapilani v Dowling, they had suppression orders, non-publication orders put on me because they didn't want me to report on another matter. They were also suing Simon Mulvaney. In relation to Jordan Shanks, it looks like they're trying to get suppression orders put on him so he can't report on the Christo Lanka matter. Now that's almost identical in a large respect to the Kapilani Honey matter. Now, and that judgment was handed down the Supreme Court of New South Wales. So given that the proceedings against Jordan Shanks is in the Magistrates Court in New South Wales, they're bound by the higher court. And that's why I raised the Kapilani v Dowling matter, because if the magistrate says, oh, I'm not bound by the Bernard Collaery matter in the ACT, well, she is bound, well, I assume it's a female magistrate, she is bound by the judgment of the Supreme Court of New South Wales. Now that was appealed, the judgment of Justice Lucy McKellum, and it went to the Court of Appeal, and I won 3-0. But there's one key line in that judgment of the Court of Appeal that I'd like to read out to you. Now in paragraph 122 of the judgment of the Court of Appeal, the last line, now I'm not going to read out the whole paragraph, but the last line says, otherwise the order, they're talking about suppression orders, they say, otherwise the order could have an unjustifiable chilling effect on freedom of speech. Once again, the suppression orders they're trying to have issued against Jordan Shanks could have an unjustifiable impact on the freedom of speech in this matter, unjustifiable chilling effect on freedom of speech. And that's why they should be fought against and fought hard. Now it's my understanding that's all it is. The New South Wales Police instituting proceedings for suppression orders against Jordan Shanks on Wednesday, but could end up being worse. They might follow through with the threat to try and have him charged for contempt of court as well. But I suppose we'll all know more after the hearing on Wednesday. Other than that, thank you for your time, and make sure you subscribe to my YouTube channel. And if you visit my website to read those articles I just mentioned, you can join up for the free email notification. And every time I publish a new article, which is normally a couple of times a week, you'll get an email letting you know there's a new article here to be read. Please share the video via Facebook and Twitter and other social media, which would be greatly appreciated. Other than that, thank you for your time and have a good day.